The Judiciary Committee will come to order and the clerk will call the roll.
Mr. Smith?
Present.
Mr. Sensenbrenner? Mr. Coble? Mr. Gallagly? Mr. Goodlatte? Mr. Lundgren? Mr. Shabbat? Mr. Isa? Mr. Pence? Mr. Forbes? Mr. King? Mr. Franks? Mr. Gomert? Mr. Jordan?
Jason?
Mr. Poe? Mr. Chaffetz? Mr. Griffin? Mr. Marino? Mr. Gowdy? Mr. Ross? Ms. Adams? Mr. Quayle? Mr. Amade? Mr. Conyers? Mr. Berman? Mr. Nadler? Mr. Scott? Mr. Watt? Ms. Lofgren? Ms. Jackson Lee? Ms. Waters? Mr. Cohen? Mr. Johnson? Mr. Pierluisi? Mr. Quigley? Ms. Chu? Mr. Deutsch? Ms. Sanchez? Mr. Polis?
Gentleman from California, Mr. Gallagly. And the gentleman from Arizona, Mr. Quayle. The gentleman from Virginia, Mr. Forbes.
Ms. Adams.
The indispensable gentlewoman from Florida, Ms. Adams. The clerk will report.
Mr. Chairman, 13 members responded present.
Reporting quorum being present, we will proceed. When we adjourned earlier this week, we were considering H.R. 4369, the Furthering Asbestos Claim Transparency Act, which was introduced by the gentleman from Arizona, Mr. Quayle, and the gentleman from Florida, Mr. Ross. We had finished debate on an amendment from the gentleman from New York, Mr. Nadler, but had not yet voted on it. I will now call up the bill so that we can resume its consideration. Pursuant to notice, I now call up H.R. 4369 for purposes of markup, and the clerk will designate the bill.
H.R. 4369, to amend Title 11 of the United States Code to require the public disclosure by trust established under Section 524G.
And without objection, the bill will be considered as read, open for amendment at any point. The question is on the pending Nadler amendment.
Parliamentary inquiry, Mr. Chairman.
The gentleman from Virginia, Mr. Scott.
Could you to remind us what the amendment is, or yield to the gentleman from New York
That's a good point, and we'll recognize the gentleman from New York, Mr. Nadler, to summarize his amendment. The gentleman is recognized for 5 minutes.
I'm yielding.
He's trying to remember the amendment.
Yeah, Mr. Chairman, the amendment would require any defendant seeking the information that the bill would make available to provide information relevant to the case that pertains to the protection of public health or safety to any other person or to any federal or state entity that has the authority to enforce the law regulating an activity relating to such information. It would make it would put an obligation to make public that information that relevant to public health or safety.
Okay. Does the gentleman yield back his time?
I yield back.
If so, thank you, Mr. Nadler. The question is on the pending Nadler amendment. All in favor say aye.
Aye.
Opposed, no. Opinion of the chair, the noes have it. The amendment is not agreed to. A recorded vote has been requested, and the clerk will call the roll.
Mr. Smith?
No.
Mr. Smith votes no. Mr. Sensenbrenner? Mr. Coble? Mr. Gallagly? Mr. Goodlatte? Mr. Lundgren? Mr. Shabbat? Mr. Issa? Mr. Pence? Mr. Forbes? Mr. Forbes votes no. Mr. King? Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Poe votes no. Mr. Chaffetz? Mr. Chaffetz votes no. Mr. Griffin? Mr. Marino? Mr. Gowdy? Mr. Ross? Mr. Ross votes no. Ms. Adams? Ms. Adams votes no. Mr. Quayle? Mr. Quayle votes no. Mr. Amade? Mr. Conyers? Mr. Conyers votes aye. Mr. Berman? Mr. Nadler? Mr. Nadler votes aye. Mr. Scott? Mr. Scott votes aye. Mr. Watt? Ms. Lofgren? Ms. Jackson Lee? Ms. Waters? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Pierluisi? Mr. Quigley? Mr. Quigley votes aye. Ms. Chu? Mr. Deutsch? Mr. Deutsch votes aye. Ms. Sanchez? Mr. Polis? Mr. Polis votes aye.
Gentleman from Ohio.
Mr. Jordan votes no.
Gentleman from California, Mr. Gallagly.
Mr. Gallagly votes no.
The clerk will report.
Mr. Chairman, 7 members voted aye, 10 members voted nay.
Majority having voted against the amendment is not agreed to. Are there any other amendments?
Mr. Chairman.
Gentleman from Colorado, Mr. Polis, is recognized for the purpose of offering an amendment.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment to H.R. 4369, offered by Mr. Polis. Page 2, strike lines 7 through 26, and insert the following.
Without objection, the amendment will be considered as read, and the gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. Essentially, my amendment would preserve state civil procedure and discovery laws and prevent federal preemption, which would otherwise occur in the current languages of the bill. As we know, this bill seeks to override state law regarding discovery and disclosure of information. In all 50 states and the various territories, we have rules that govern disclosure of a trust claimant's work and exposure history, extensive case law, and various rules regarding that discovery. If the information is relevant to a state law claim, a defendant can request and obtain that information according to the state discovery rules. Now, what state discovery rules do not allow, and what asbestos defendants are seeking through this bill, is a fishing expedition totally above and beyond state civil procedures for irrelevant information, which has no other use than to continue to delay or hinder or obstruct an asbestos victim's claim for compensation and ultimate resolution of these claims. The bill in its current form really infringes on states' rights to determine their own discovery rules and rules of civil procedures. Now, as we know, asbestos litigation is brought under state law. The vast majority of claims are filed in state court and properly litigated according to state court rules. Now, we began this session of 112th Congress by reading the Constitution, and we frequently talk about our respect for the Constitution on both sides of this body, including the Bill of Rights. And under the 10th Amendment, powers not specifically granted to the federal government nor prohibited to the states are reserved to the states. This bill would upset the careful balance of federalism as preserved in the 10th Amendment by overriding state discovery and civil rule procedures with a federal takeover of discovery rules. This amendment ensures that states' rights are respected by ensuring that defendants abide by state court rules. The bill also infringes on states' rights by preempting state law. Now, under many states' laws, defendants, including asbestos defendants, are held jointly and severally liable for a plaintiff's harm. This bill preempts state joint and several liability law by giving asbestos defendants automatic access to trust information, basically allowing them to avoid liability in joint and several liability states. So, again, we have a 10th Amendment issue. We have an issue with preempting the rules in state courts and effectively advocating a federal takeover and micromanagement of how states regulate discovery. My amendment would address that. It restores the appropriate balance of powers, and for any claim pending in court, it's the appropriate and exclusive role of the judiciary to determine what information will be made available through discovery, not to be micromanaged by Congress.
Would the gentleman yield?
Yes, I just have another moment, and then would you like to speak? Would you like to get your own time, or do I'll be happy to yield to the ranking member.
All
I
wanted to find out is it correct that the bill shifts the cost of discovery to the trust?
That is correct. Yes.
Thank you.
A further disincentive to seeking justice for victims. My amendment would restore the appropriate balance of powers and allow defendants to overwhelm the trusts with needless information requests, as the ranking member indicated, that are not relevant to their claim, nor discoverable under state rules. So again, it's a very straightforward amendment. It strikes Section 2 of the bill. Obviously, I think there's the opportunity to discuss the asbestos tort issue and towards a final resolution. But a federal takeover of the micromanagement of discovery rules and the severability of liability is not a constructive part of an answer, and it's a very antithesis to the federalism that many on this panel have espoused on a number of issues. And absent an overarching deal in this area, I think is a very perilous path to go down with regard to the preemption of state civil procedure. And I also thank the ranking member for pointing out the additional delays and costs that victims would incur in seeking justice. I urge a yes vote on the amendment, and I yield back.
And thank you, Mr. Polis. The gentleman from Arizona, Mr. Quayle, is recognized.
Thank you, Mr. Chairman. I thank the gentleman for his amendments and his love of the 10th Amendment, as do I. I love states' rights. But don't, rest assured this does not violate any states' rights, because the trusts are actually continue to be maintained by the bankruptcy courts, which is a federal issue. And so by allowing the transparency into these trusts to save the trusts from actually being depleted by fraudulent action, I think that this is a good bill. It's transparent, and to address the point that the ranking member made, that the manager's amendment actually provides that the trust may elect to charge reasonable costs to the party seeking discovery. Therefore, the discovery obligation should cost the trust absolutely nothing. I also oppose this amendment on other grounds, because it essentially replaces the quarterly report and discovery sections of the bill with a simple requirement that the trust provide limited discovery to a party to a pending state court action relating to asbestos exposure, provided that discovery cannot otherwise be attained through applicable non-bankruptcy law. The problem with relying on non-bankruptcy law for discovery is that many of these trusts prohibit disclosure of any information except by subpoena issued by the bankruptcy court. For example, The Babcock and Wilcox Personal Injury Asbestos Settlement Trust plan now provides that the trust will preserve the confidentiality of such claimant submissions and shall disclose the contents thereof only in response to a valid subpoena of such materials issued by the bankruptcy court. With respect to this and other trusts, state law discovery procedures don't make the cut. Moreover, plaintiffs in asbestos litigation cases frequently resist discovery requests made to the trust. An example, one witness at the FACT Act hearing last month noted was a recent filing by plaintiffs of a blanket joint motion for a protective order asking the court to prevent the disclosure of the terms and supporting documentation of any settlement entered into between any plaintiff and any trust. I would refer my colleague to the hearing testimony of Leanne Schell, who has witnessed firsthand the extreme difficulty that state court litigants face when trying to get discovery of trust documents. The bottom line is that a federal statute is needed to ensure that state court litigants have access to the records of 524G trusts. Applicable non-bankruptcy law, the recourse to which the gentleman's amendment would leave litigants is demonstrably inadequate. The FACT Act streamlines discovery. My manager's amendment makes clear that the trust will bear no financial burden for complying with discovery requests. I encourage my colleagues to oppose this amendment, and I yield back the balance of my time.
And thank you, Mr. Quayle. Are there other members who wish to be heard on the amendment? If not, the question is on the amendment. Those in favor say aye. Those opposed say nay. Opinion of the chair, the nays have it, and the amendment is not agreed to.
Mr. Chairman, I request a recorded vote.
Gentleman asks for a recorded vote, and the clerk will call the roll.
Mr. Smith?
No.
Mr. Smith votes no. Mr. Sensenbrenner? Mr. Coble? Mr. Gallagly? Mr. Gallagly votes no. Mr. Goodlatte? Mr. Lundgren? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. Pence? Mr. Forbes? Mr. Forbes votes no. Mr. King? Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Jordan? Mr. Jordan votes no. Mr. Poe? Mr. Chaffetz? Mr. Chaffetz votes no. Mr. Griffin? Mr. Marino? Mr. Gowdy? Mr. Gowdy votes no. Mr. Ross? No. Mr. Ross votes no. Ms. Adams? Ms. Adams votes no. Mr. Quayle? Mr. Quayle votes no. Mr. Amade? Mr. Amade votes no. Mr. Conyers? Mr. Conyers votes aye. Mr. Berman? Mr. Nadler? Mr. Nadler votes aye. Mr. Scott? Mr. Scott votes aye. Mr. Watt? Mr. Watt votes aye. Ms. Lofgren? Ms. Jackson Lee? Ms. Waters? Ms. Waters votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Pierluisi? Mr. Pierluisi votes aye. Mr. Quigley? Mr. Quigley votes aye. Ms. Chu? Mr. Deutsch? Ms. Sanchez? Mr. Polis? Aye. Mr. Polis votes aye.
The gentlewoman from Texas, Ms. Jackson Lee.
Not recorded, ma'am. Aye. Ms. Jackson Lee votes aye.
Gentleman from Florida, Mr. Deutsch.
Mr. Deutsch votes aye.
Okay. Are there any other members who wish to be recorded? If not, the clerk will report.
Mr. Chairman, 11 members voted aye, 12 members voted nay.
Okay. A slim majority having voted against the amendment. Amendment is not agreed to. Are there any other amendments? If not, before we go to final passage on this bill, I want to thank members for their participation this week. This has been a rare week with our having two markups on 2 different days, but I do want to point out that even though there wasn't general agreement on these last 2 bills, that of the 6 bills this committee marked up this week, 4, in fact, were bipartisan bills. and that is a tribute to this committee and to the ranking member for helping us get those bills across the final finish line. Reporting quorum being present, the question is on reporting the bill as amended favorably to the House. Those in favor say aye. Opposed, no. The ayes have it, and the bill as amended is ordered reported favorably. The request had been made for a recorded vote, and the clerk will call the roll.
Mr. Smith?
Aye.
Mr. Smith votes aye. Mr. Sensenbrenner? Mr. Coble? Mr. Gallagly? Aye. Mr. Gallagly votes aye. Mr. Goodlatte?
I don't see what's gained.
Mr. Lundgren?
Recorded vote on that. We're gonna.
Mr. Shabbat? Mr. Shabbat votes aye.
I think the few
Mr. Isa?
votes on final, the better, because everybody can be hit one way or the other.
Mr. Pence? Mr. Forbes? Mr. Forbes votes aye. Mr. King? Mr. Franks? Mr. Franks votes aye. Mr. Gomert? Mr. Jordan? Mr. Jordan votes aye. Mr. Poe? Mr. Chaffetz? Mr. Chaffetz votes aye. Mr. Griffin? Mr. Marino? Mr. Gowdy? Mr. Gowdy votes aye. Mr. Ross? Mr. Ross votes aye. Ms. Adams? Ms. Adams votes aye. Mr. Quayle? Mr. Quayle votes aye. Mr. Amade? Mr. Amade votes aye. Mr. Conyers?
No.
Mr. Conyers votes no. Mr. Berman? Mr. Berman votes no. Mr. Nadler? No. Mr. Nadler votes no. Mr. Scott? Mr. Scott votes no. Mr. Watt? Mr. Watt votes no. Ms. Lofgren? Ms. Jackson Lee? Ms. Jackson Lee votes no. Ms. Waters? Ms. Waters votes no. Mr. Cohen? Mr. Cohen votes no. Mr. Johnson? Mr. Pierluisi? Mr. Pierluisi votes no. Mr. Quigley? Mr. Quigley votes no. Ms. Chu? Ms. Chu votes no. Mr. Deutsch? Mr. Deutsch votes no. Ms. Sanchez? Mr. Polis? No. Mr. Polis votes no.
And gentleman from Arkansas,
Mr. Griffin votes aye.
gentleman from South Carolina,
We need time.
and gentleman from Arizona.
Mr. Franks votes aye.
Are there other members who wish to be recorded?
Mr. Chairman,
Who seeks recognition? Oh, the gentleman from Virginia, Mr. Forbes.
Mr. Chairman, how am I recorded?
How's the
Mr. Forbes has voted aye.
Oh, thank you, Mr. Chairman.
Who seeks recognition?
Mr. Chairman,
The gentleman from Arizona.
how am I recorded?
Mr. Franks has voted aye.
Thank you.
Mr. Chairman.
The gentleman from Ohio.
Mr. Chairman, I'd like to make absolutely sure how I voted on this particular issue.
And how was that? The gentleman has voted.
Mr. Shabbat's voted aye.
Mr. Chairman.
Let me say to the members, we're going to hold this vote open for a couple of minutes. I can hear footsteps in the hall, and we don't want to deny anyone the opportunity to vote on such an important piece of legislation.
Mr. Chairman, could I call for regular order, please?
The ranking member's call for regular order has been heard, is being considered, and will be ruled on shortly. Let's go back to the days of proxy votes.
Mr. Chairman, I again call for a regular order, please.
Mr. Chairman?
Thank you, Mr. Conyers. The gentleman, yes.
Mr. Chairman, is the pending vote the Medicare drug bill?
I didn't understand the gentleman.
Is the pending vote the Medicare drug bill? That was held open for 3.5 hours.
That was another time, another year, and as I recall, that vote was held open for 3 hours and 12 minutes.
Yes,
So,
it was.
we have no intention of breaking that record here today.
I would hope not.
In fact, I expect that we'll be able to close the vote in a couple minutes. And now, this is expected to be the last vote of the day. Those who have already voted are free to leave with faith.
But then you'd lack a reporting quorum.
Point of parliamentary inquiry, Mr. Chairman.
Who seeks recognition? The gentleman from Florida, Mr. Deutsch.
Mr. Chairman, is it the point of parliamentary inquiry? Is it the chairman's prerogative to hold open votes?
It
for
is the
indefinite
chairman's
period?
prerogative to hold open the votes for a reasonable amount of time. That to be defined, of course, by the chairman.
I thank the chairman for his thoughtful response.
Mr. Chairman, might I ask for a unanimous consent request? We're in the middle of something.
No, the
to make that
gentleman is recognized for unanimous consent request.
I ask unanimous consent that the vote be held open for our side for an equivalent amount of time after you get your votes for us to get our people here.
Yeah, the vote is being held open for both sides. Anybody can walk into the door at any point, so I'd have to object to the gentleman's unanimous consent request. I thought it was going to be for documents in the record or something like that. But.
Well, I assume the record will document itself as to how the rules are being twisted and turned and used for the benefit of the chairman.
Mr. Chairman? Mr. Chairman?
The gentleman from Arizona is recognized.
Could I engage in a colloquy with the chairman?
Yes, the gentleman is recognized to engage in a colloquy. Does the gentleman still want to engage in a colloquy?
Mr. Chairman, that's up to you.
Let's recognize the gentleman from Virginia, Mr. Goodlatte, for his vote.
Mr. Chairman.
The gentleman from New York. If not, we're going to close the vote.
Mr. Chairman, how am I recorded, please?
Mr. Nadler has voted no.
I'm sorry, Mr. Chairman, I didn't hear that.
Mr. Nadler has voted no.
You sure I voted no?
And
Yes.
the clerk will report.
Mr. Chairman.
Mr. Chairman,
Mr.
Mr.
Chairman.
Sanchez is...
Oh, the clerk will not report yet. The gentlewoman from California.
Not recorded, ma'am. Ms. Sanchez votes no.
Oh, the gentleman from California, Mr. Isa.
Mr. Isa
Gentleman
votes
from
aye.
California votes aye. The
Mr.
clerk,
Mr. Chairman.
gentlewoman from Texas, Ms. Jackson.
Am I recorded?
Ms. Jackson Lee has voted no.
What did you say? I'm sorry.
No.
No. Thank you.
Mr. Chairman?
The clerk will report.
Mr. Chairman, how did the Cubs do last night?
Mr. Chairman, 15 members voted aye, 14 members voted nay.
And the ayes have it, and the bill is amended, is ordered reported favorably. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating amendments adopted. Staff is authorized to make technical conforming changes. Members will have 2 days to submit their views. I thank all members. We stand adjourned.